Good afternoon and welcome to today's Brennan Center for Justice event. For those joining us for the first time, the Brennan Center is a nonpartisan law and policy institute that works to repair, revitalize, and defend our systems of democracy and justice so that they work for all Americans. I'm Hernandez Stroud, Senior Fellow in the Brennan Center's Justice Program, and I'd like you to join me in welcoming our panelists. Rachel Barkow, Charles Siegelson Professor of Law at New York University School of Law and author of a new book, Justice Abandoned: How the Supreme Court Ignored the Constitution and Enabled Mass Incarceration, and Preet Bharara, who served as U.S. Attorney for the Southern District of New York for 8 years under the Obama administration, and he is now a partner at WilmerHale. Thank you both for joining us. So tonight we are going to discuss an aspect of the United States mass incarceration crisis that often goes overlooked, and that is the role of the Supreme Court. Since the 1960s, the court has handed down decisions that laid the foundation for the over-incarceration and excessive punishment we see today. Rachel examines 6 of these cases in her book, Justice Abandoned, breaking down where the justices got it wrong and how each ruling directly or indirectly fueled mass incarceration. We will explore those missteps and the implications for the criminal justice system, and we'll consider how the current court can change course and play a role in fixing the crisis that it helped to create. Now, on to the question. So, Rachel, I want to talk big picture and really get a sense of why you wrote this book. And so, if you can tell us why you wrote this book and maybe walk us through a few of the court's key decisions that, in your view, directly or indirectly contributed to this problem of mass incarceration.
Yeah, sure. And first of all, thank you all for being here. I realize you were away from your phones during the time that we're here, and it's been a very busy day. So thank you. So the reason that I wrote this book is because I'm very interested in why America is such an outlier in the world when it comes to its approach to criminal law and punishment. Because as many of you may know, we're responsible for a huge chunk of the world's incarcerated population. Even though we're only 5% of the world's population, we account for about 20 to 25% of the people that are in prisons and jails. And there's a question of kind of what it is about America that produces such a punitive culture. And for the most part, what I have written and focused on in my scholarship are our political dynamics, the push for severity that our politics produces. And the last book I wrote was really all about that, kind of the political dynamics of why you kind of constantly get that push for severity. And at the end of that book, I tried to suggest some ways to remedy our dysfunctional politics. And the last chapter was about the courts. And I said, there are these constitutional protections, so, we just haven't seen much enforcement of them. Maybe that's just because of the kind of people that we have on the bench. Maybe it's because we do, no offense, Preet, have a lot of former prosecutors, and we don't have a lot of other people who have done civil liberties work or defense work, and maybe we should think about a different kind of judiciary. And I sort of left it there, but it was gnawing at me after I wrote the book, just kind of thinking about, because I just kind of very briefly said, because there are actually a lot of these kind of constitutional arguments that could be made. And then as I started thinking about it more, I really started thinking about, but why weren't they successful previously? Like exactly what happened in these cases? And I started digging deep into some of the cases that have most interested me. And as soon as I did that, I realized there is a story to tell here about the Supreme Court and the Supreme Court's role in these critical areas where it should have held a constitutional line against some of these governmental practices, and the court caved. The court caved either because the government was saying public safety required it, or because the court was saying administrative efficiency. And just to give you an example of something like that, so in 1968, bonkers year in America. It's a good thing we didn't have Twitter, I think, in 1968. When the people running for president, Richard Nixon, George Wallace, they were running these campaigns that were very law and order, very much there's lots of protests turned to riots, cities in America are burning. crime is up, homicide rates are up. You know, it's really a time that seems like there's a lot of disorder. There's 2 major political assassinations. And during the political campaign, there is a lot of focus on the Supreme Court, that the Supreme Court is in part to blame for this, because the court had decided, Mapp versus Ohio, where the court had said if you get evidence, you obtain it in an unconstitutional manner, it's excluded from a case. And that led to lots of editorials around the country, an outcry from the police that said, you know, guilty people are going free because of this technicality that the court is allowing. And the court had also decided the case of Miranda, where people get their warnings that they have a right to counsel, and that too led to a backlash where people are saying now they're not talking, cases are going unsolved. So the court was very much targeted in 1968. People had impeach Earl Warren signs on their lawn, you know, the Chief Justice. So you can imagine if today, you know, that was a big yard sign in a presidential campaign. And I think the court was very sensitive to that. So in 1968, when they're deciding the case of Terry versus Ohio, so it's a policing case where the claim is that the police should be able to seize people, stop people on something less than probable cause, right? The idea, if you go up, you look in the Constitution, you'll see it's probable cause is the textual standard. That has always been the standard for being able to seize people and to search them. That the government needs probable cause you're committing a crime or about to commit a crime. But the claim in Terry versus Ohio is, come on, you can't make the police have to show probable cause. Can't they just kind of, you know, just a stop and frisk? It's just a stop, it's just a frisk. It's a search, it's a seizure. But ultimately what the court decides, because it's 1968, and I really, you know, first they were gonna write an opinion when you go through the papers. It's so interesting because they take their vote and they're like, we gotta let the police do this. And then the idea is that Warren is going to write the opinion, and he does a first draft just trying to claim there was probable cause, which it won't write because there wasn't any, because the officer, the facts of that case, and I'll wrap up after this. So the facts of the case are, there are these 2 guys walking back and forth on the sidewalk 3 times, and then they're joined by a 3rd man. And the 2 men who are walking initially are black. The 3rd man who joins them is white, and then they talk amongst themselves, and then they disperse. And that's when the officer stops them and frisks them. And so you might ask, was there a probable cause? Well, what were they doing, Officer McFadden? And he said, well, you know, they were looking suspiciously in that window of the airline ticket office. So when the Supreme Court tries to draft the opinion saying there was probable cause that they were about to commit a crime, it doesn't write, right? The other justices are like, this is garbage, we can't join this. So they come up with this idea that becomes a Terry stop, right? It's invented. It comes poof, you know, it's truly out of nowhere. We accept it today, and here in New York, you know, 750,000 people at its peak have been stopped because of Terry. You know, people's lives really disrupted in horrible ways because of terrible interactions with the police, because the court decided to give the police this new power that violates the Constitution's text, its original meaning, because of this kind of environment that it was in. And the other 5 cases are like that. They're basically kind of these scenarios where when you look, you would say, wow, no originalist would have joined this opinion. You know, no one who cares about original meaning, no one who focuses on the text. Why do they do it? And it's this atmospheric climate where I think the court feels pressure to defer to the government when the government says it needs to do something. And so that's the overarching theme, really, of the book, is that there are these constitutional protections. It's just we didn't have a Supreme Court that was willing to uphold them. And each of these areas that I talk about end up being hugely important for mass incarceration, because, you know, if it turns out you make it really easy for the police to interact with people, even if most of those interactions don't produce arrests, many of them do, and before you know it, you're churning lots of people through the system. And so that's also true of what the Supreme Court does with pretrial detention, with plea bargaining, with not policing sentence length, with prison conditions, with racial discrimination and its proof. And those together, you know, land us where we are today.
Thank you. So I actually want to drill down. I was thinking about asking about, you know, what parts of the Constitution's text or history led you to this provocation that, you know, the framers would have been appalled by the American carceral state. But I'm actually interested in asking a different question, and it's essentially, you know, I know in private conversations you're not Pollyannish about any of this, or the, you know, the magnitude of the court's role among other factors. And so I guess my question is, if some of these cases had come out the other way, do you think it would have made a difference in the composition of the American carceral system? You know, in other words, would we have as much mass incarceration today?
We'd still have a lot. And you could have stopped that sentence as you're just not Pollyanna, or you're just kind of pathologically pessimistic, which I am. But we wouldn't have the scope and the sweep that we have today. And one of the reasons why is because you have to keep in mind that for most of our country's history, we did look like the rest of the world. It's not until about 1970 that our incarceration rates start to climb and we start to diverge from other Western democracies. So everything gets kicked off in this kind of period. And the reason is because as the court is kind of relaxing all these standards, you're building up bigger police forces and more prosecutors, and you're building more prisons, and you're having longer sentences. And so without anything to stop or slow that down, it really snowballs. And I think had the court held back on some of these things, we'd still have the same political dynamics, but they wouldn't have been able to have the kind of speed or ferocity that they ultimately do. So, I think if you didn't have Terry, for example, and you had to have probable cause to stop somebody, you'd still be able to find a way to do it. You'd just stop them for the kind of minor crimes that get enacted, that the legislature enacts, and then, you have probable cause that you're loitering, or you probable cause that you jumped the turnstile. You'd have ways to have lots of police and citizen interactions. But it still wouldn't be as easy as it is with Terry. So, you'd have some reduction. And it's like that for each of these areas where if you couldn't, a big one is plea bargaining. So the court allows the government to threaten people with really long sentences if they go to trial. If you exercise your right, which you have a constitutional right to a jury trial, if you face punishment of 6 months or greater. And normally what the Supreme Court says is that the government can't burden constitutional rights. Can't place unconstitutional conditions on the exercise of your right. But it doesn't take that approach with your jury trial right. And so the government, for example, in the case that I talk about in the book, this guy, he forges a check for $88.30 at a grocery store, and he's charged with a crime that has a 2 to 10 year sentence. The government says, if you plead guilty, 5 years. And the government also says when he doesn't want to plead guilty to that, if you put me, this is what the prosecutor admits, if you put me through the inconvenience of a trial, I'm gonna supersede your indictment, and I'm gonna charge you with this recidivist law that existed, and if you're convicted, you'll get a mandatory life sentence. So a mandatory life sentence for an $88.30 check. And that seems pretty coercive to me, right? You want to exercise your jury trial right? Do you want to risk a life sentence? And the Supreme Court says that's fine. And that, allowing that to happen means that you can have really coercive plea negotiations, and that for sure feeds this engine of mass incarceration. Had the court placed a limit on that, I think absolutely we'd have a much more reduced prison population than today. So I do think we wouldn't have quite what we have as its scale or scope. And it's possible that if you couldn't do some of these things, it may have also created incentives for legislators and politicians to look for other solutions to social problems other than just constantly throwing prison at it. And so I do think it's hard to know what the alternative reality would have looked like completely. I still think it would be pretty bad, but I don't think it would be anything like what we're experiencing today. And I actually think we would have had some interesting experimentation with other approaches that may have led to kind of positive examples that other jurisdictions would adopt.
Thank you. Preet, I want to turn to you and draw on your practical experience as a former top prosecutor of the storied SDNY, as well as your experience working on the Hill on the Senate Judiciary Committee for a number of years, where you saw criminal justice policy. So some of the policies and practices we have discussed existed long before the Supreme Court sanctioned them. So my question is, how much blame do you think we can lay on the court, and do you see a clear shift in our approach to criminal punishment before and after these rulings?
It's great to be here. Thanks for joining us. Thanks also to the Brennan Center and NYU Law School, and to you, Hernandez, for all the great work that you do and that the center does. So what's interesting about your question and the things that I was just hearing Rachel talk about is, from my experience, both in the legislative branch and the executive branch, being a law enforcement person, you become familiar with the one-way ratchet, right? So it becomes very easy if there's a crisis or a problem, whether it's 1968 or it's 2001 after 9/11, or some other thing happens, and lots of people cry out for some solution. They don't know what it is. Not everyone is a criminologist or a law enforcement expert or a judicial expert, and they say, do something. And the easiest thing to do in the face of a rising crime rate or a terrorist attack or any other such thing is to do the thing that is within your power to do. You know, that famous phrase, if you're a hammer, everything looks like a nail. If you're a prosecutor, everything looks like a crime. If you're a legislator, everything looks like it should be solvable through passing of legislation. And legislation that is easier to pass than not is the kind of legislation that gets brought to bear. And so once you do that, once you create a mandatory minimum, it becomes very, very difficult politically to undo the mandatory minimum. Once you decide you're gonna raise the maximum statutory penalty for a crime, it becomes very difficult to undo that. And over and over and over and over again. What's interesting to me, so for example, there would be a particular kind of crime somewhere, or a politician was up for re-election, and they were facing somebody from the right who was saying, you know, this senator or this member of the House is soft on crime. Well, the easiest way to solve that if you're an incumbent is to look like you're strong on crime. And the easiest kind of bill to put forward doesn't even have to pass as an independent statute or law, as an amendment to something that someone else. So I would be at markups, you know, where we would vote on bills, where the members would vote on bills. And somebody would propose some tough law. And don't get me wrong, I thought I was pretty tough and aggressive, hopefully appropriately, as U.S. attorney, but I would witness somebody propose a pretty tough law on something that maybe was already covered by other statutes, and then there would be an amendment, and the amendment wouldn't be to soften the bill, it would be like, no, it should be twice as much time in prison. And so I kind of understand that there's gridlock and there's persistence and stickiness of that kind of one-way ratchet up. We can talk in a moment about prosecutorial discretion, that's a little bit different. But on the legislative side, and what's interesting to me in hearing you talk, Rachel, is we also seem to have that kind of stickiness in criminal justice issues in the court. It's kind of quaint in a way that that you talk about and write about a time when, and people have different views about this depending on the issue, but there was a time when the court was sort of responsive to the political climate in the country. And I sort of wondered as you were speaking why it might be that there's more stickiness with respect to some of these constitutional precedents with respect to criminal justice issues than, for example, the right to an abortion or the policy of affirmative action, because times have changed and the crime problem has abated. So I'll just reserve that question for you, subject to the chair.
I approve.
Okay, thank you. So it's a really great point, and it's actually one of the things that I sort of would like the book to do is for people who claim to be originalists, people who believe that what we should do when we read a constitution is interpret its original meaning, what the framers intended and put in the body of the document when they wrote it, you know, what its meaning was. That is the ground on which a lot of the current Supreme Court justices have overruled, for example, Roe versus Wade in Dobbs, even though it was a 50-year-old precedent. I believe it is going to be the basis on which the court is going to strike down what are known as independent agencies. So agencies where the head of the agency can only be removed for good cause. You may have noticed that a lot of people have been fired from these agencies by President Trump, and there have been legal challenges to that. And the cases are making their way through the courts, but the court has already allowed the firings to stay, you know, that those people can kind of stay in the position that they're in right now, because it is signaling that is going to overrule a 90-year-old precedent in which those agencies' creation, having that kind of structure, was held to be fine. And I think what the court, a majority of the court, is probably going to say is that no, the original framing understanding of our separation of powers is the president has to be able to fire everyone who's in the executive branch. And they're gonna, so that would undo, if they do that, that would undo 90 years of precedent and a huge swath of our governmental structure. So it would be massive, right? In the same way that Dobbs was massive. And when the court does those things, it claims, hey, we're just doing our job, we're just originalists, we just follow the law where it takes us. And what I like about these cases and pointing this out is that the originalist case for these, 5 of the 6, I will admit the 6th one we can talk about if you want to, McCluskey, but 5 of the 6, like slam dunk on originalist grounds, they shouldn't have been decided the way that they were. And so if the court were to get challenges on these cases, it will be faced with one of 2 options. Either they can be principled and consistent and say, oh my gosh, you're right, Salerno, where we allowed pretrial detention for somebody presumed innocent, that completely violates the due process clause. For 200 years, we never allowed that. That was never okay, and all of a sudden we just kind of created this idea that it was permissible. We should overrule Salerno to be consistent. Either they'll do that, and it will be like, okay, yeah, I guess you're originalist and you take the law wherever it takes you, or they won't do it, and they will be exposed as hypocrites. They will be exposed as, I know, I'm shocked that it's a possibility, but it would be that it's results oriented. But I genuinely wonder if they will want cases where they can come out and show that even if it's an outcome that looks more liberal might be attractive, because I remember, Justice Scalia used to when he'd go on the speaking tour circuit, very conservative guy, and he would bring this up all the time, in the flag burning case. I don't believe you should burn an American flag. It's terrible, but I voted that people have the right to do it because I don't just vote on cases based on the outcome that I want. And he liked it. It was good, right? It was good for him to be able to say, hey, as it turns out, sometimes my methodology means I have to vote for things I don't like. The current justices don't really have examples like that. As it turns out, they like every outcome. Every outcome it just so happens the framers, produced every outcome that they want. So I think these cases would be good for putting them to that test. And we either could get better substantive outcomes because they would be principled, or I think it would help to, again, maybe raise up the stakes of what it is the court is actually doing when it's saying it's deciding based on this methodological commitment, but in fact may be more of a policy call that it's making in cases.
It's one addendum. There may be other exceptions to the general upward ratchet and the increased incarceration likelihood for people in this country. The one exception to that is that today, the one category of person who's less likely to be incarcerated than some years ago is a powerful elected politician who engages in corruption.
All right. So I actually want to stick with this idea of sort of supposing the court reverses course in some world and strikes down certain policies, again, on principle, around, for example, pretrial detention or coercive plea bargains. What kinds of changes might, if those sorts of decisions came down, we actually see in jails and prisons? How much impact would new court decisions really have on chipping away at mass incarceration in practice?
I don't know. It's hard to say. And I should point out a couple of other distinctions as well when we talk about this generalized issue of mass incarceration. We have 2 systems. Actually, we have scores of systems, but we have 2 generalized systems. The federal system, which is the one, excuse me, that I participated in and was involved with. And then you have 50 state court systems, and you have local systems as well. And most of the mass incarceration, as you might imagine, given that most of the criminal law enforcement resources are expended at the state and local level, that even if you change things having to do with the federal system, you're not going to affect mass incarceration all that much because of the numbers. The way I think about your question, and the way I think about a lot of things is, since we've been talking about the court and we've been talking about the legislature and the laws passed, you can make an argument that none of that matters as much as how prosecutors culturally decide to exercise their discretion. And so, to the extent that these changes in Supreme Court opinions or decisions might have an impact on this ultimate question that we've been discussing, I think the most important way in which that would happen, it's not hard, it would be a soft change in culture on the part of prosecutors and prosecutors' offices, right? I wrote in a book that I put out a few years ago that if prosecutors went after every single possible target and charged every possible crime that they could lawfully and constitutionally under our system, we would be living in a hellscape. No prosecutor's office does that, even the ones you think that are the most draconian. One reason is they don't have the resources to do it. And the other is they make decisions, and sometimes those are politically motivated policy decisions. Sometimes there's something else. One district attorney decides, in his or her jurisdiction, that going forward we're not going to prosecute fare beaters on the subway any longer, and that has a certain effect on incarceration. Another decides that on the federal level that we're not going to prosecute people who re-enter the country illegally unless they were previously deported from the country after having committed a crime, which was a policy adopted by my predecessor in the Southern District of New York. And to the extent that those Supreme Court cases might be, sort of harbingers or signals or sort of guides to what enlightened criminal justice policy are, then that might have a cascading effect and a ripple effect on prosecutors. And I don't know if you wanted to pit. I'm going to reserve another question for our author here. Now a lot of pressure. It's got to be a good question.
You approved even before you heard it, though.
I know. I'm sure it's going to be a good question.
Now I forgot what the question was. I totally forgot what the question was. Oh, if you're going to pit against each other in terms of impact, I guess it depends on the particular decision, because some could be very stark, like the Miranda warning. Like, kind of have to give the Miranda warning. That's not just an effect on. So that's an example of one, I think, where the court decides to amplify and further protect the right against self-incrimination, and it's so specific and precise that the whole world knows about the Miranda warning if you watch any television or police procedural, and it becomes embedded in the culture. That's maybe an outlier, but otherwise, if you're going to sort of test the premise of what has more impact, a judicial decision of a certain type, or a change, a significant and material change in culture among prosecutors, which would have a more material effect on mass incarceration, that's my question.
Yeah, I would always choose to change culture and norms, if I was forced to choose.
Even though that's softer and not enduring.
Yeah, I mean, I think, well, I guess the hope is it is enduring, because I do think that these things become self-fulfilling prophecies. I mean, law is really important, and I guess I should say that the reason that I think, right, the reason that I think these cases matter is because I do think they're both. I think they are both, like you said. I think they would both be setting a legal, a ceiling on things you could do, but they would also be cultural signals, and that's the other reason why I think they're so disturbing, because I think in these cases, when you read them and you read the briefing, you just realize that the court was sending a signal: government, do what you got to do. There are these constitutional protections, but wow, these are scary times. Do what you have to do. And I do think that actually did have a cultural impact. Or to give you another example of that, so one of the cases that I talk about in the book is United States versus Salerno, which is the first time that the Supreme Court says it's okay to detain somebody after they've been arrested because they're dangerous. And now you might think, well, I mean, haven't we always done that? Isn't that what you do when people are arrested and they're dangerous? And the answer is no, we didn't do that, because you are presumed innocent until after your trial and you've been convicted. And so in the United States for 200 years, every legal scholar, academic, practicing lawyer operated under the belief that the only way you got somebody detained after an arrest is because they were a flight risk, they would intimidate or harm a witness or evidence. So the reason you detained them was to make sure you could preserve the trial. Now, if you thought someone was dangerous, there was this other way you could detain them, which is what we still have, which is civil commitment, right? It's not about the arrest. It's just saying there's this person that might have a particular mental health issue or something that makes them a danger to themselves or others. But the fact you were arrested would not be a basis for detaining somebody, right? For that, you needed to have a trial to show, that they did the thing that they were accused of, because that's what our presumption of innocence is all about. You get that trial. When the Supreme Court decides the case of Salerno, that the court says, nah, the presumption of innocence, that's just like a burden of proof thing. It has no bearing on this. When you detain somebody after arrest, that's a regulatory thing. It's not punishment. Now, if you ask anybody in Rikers Island or in jails across America whether they're experiencing punishment or not, or if it's just a regulatory matter, I think you would find that, of course, that is an insane distinction that the court was drawing. But what I think is interesting about that case is I don't claim before Salerno that there weren't judges around the country who looked at certain people who had been arrested and thought, oh my gosh, this person's really dangerous. And even though I'm not allowed to detain them because they're dangerous, I'm gonna say maybe I think they're a flight risk, or I'm gonna set their bail amount really high because I do think they're dangerous and I don't want them out. That absolutely happened. It kind of, it was happening like on the down low. That happens in New York because we're the last state to not allow detention on the basis of dangerousness. It's still supposed to be the traditional way, and yet we still have an awful lot of people who are detained pre-trial. So it's not that I think that changing this legal standard would be magic, but I do think it would be far less than what we have, because on any given day in America, you have about 500,000 people who are incarcerated in jails as opposed to prisons, and most of the people who are in jails are there pre-trial. They haven't been convicted of anything, so they're awaiting their day, and they're there for really long periods of time. In the federal system, for example, 75% of all federal defendants are detained pre-trial. 75%. So you're arrested on a federal charge, you are detained pretrial, and the average length that you are incarcerated before you've ever had your full-blown trial is over 8 months before you get your process. And so I think that the difference between the court saying, yeah, that's fine, that's okay, and it's not okay, and you kind of have to do it as a matter of subterfuge, is a cultural message. Because I think once the court says it's okay, then I think the way that filters out to prosecutors is that, well, it's fine. I don't even need to think twice about it. And not only do I not need to think twice about it, but I have my own political pressures I'm facing, because most prosecutors, unlike federal prosecutors, they're elected. And if you're an elected prosecutor, I think one thing you really don't want to have happen is that somebody that you have charged with a crime, if you didn't ask to have them detained and they are released pre-trial and they commit some other heinous crime and they're on the cover of the New York Post or the Daily News having committed it, and it comes to find out you didn't ask for their detention, that is like the worst thing that can happen for your reelection prospects, right? That's gonna be all over you. And same for judges who are elected. No judge wants to be held to blame for the fact that they didn't detain someone who went on to do that. And so that political dynamic means every incentive is to just over-detain people. And because there's no legal impediment to doing that, and there's no even kind of, let's think twice about, can we say that there's a kind of flight risk or some other thing, I think it just becomes the norm. And so now, fast forward, so in 1968, when there's this first idea to allow detention on the basis of dangerousness, that same election year, by the way, after Richard Nixon was elected, he realized, now what do? I ran on this whole law and order thing, and I'm actually the president of the United States, and I'm not really responsible for local crime, uh-oh.
So he decided to commit some himself.
Right, and
his contribution.
Yes, his contribution was that, and to have someone in his administration write the first law that would authorize detention on the basis of dangerousness in the District of Columbia. The person he asked to write that was William Rehnquist, who was a member of the Nixon administration. So he writes the law, and then weirdly, the Attorney General, it's kind of hard to imagine Pam Bondi doing this. The Attorney General writes a law review article explaining why this law is actually constitutional. And it's really pretty terrible. Like, you read it and you're like, this is really flimsy, this is not very persuasive. And there's a response article written by Larry Tribe that just decimates this thing. But it's a concerted effort to change the norms, change the culture, change the law. And ultimately Nixon gets 4 appointments to the Supreme Court. One of them is William Rehnquist. Rehnquist is the one who writes the opinion in Salerno saying it's all okay. So, they are able to make a cultural shift, a legal shift, all in one swoop. And now, fast forward to today, when I talk to people about pretrial detention, nobody, like, people think, what are you, crazy? Of course we have to detain people pre-trial. You're not gonna just like release them. And I think, but there was another time where we released most people and it actually was okay. And we're over detaining people now. And as it turns out, it makes us less safe because, when you're detaining someone, they're losing their job, they're losing their housing, they're losing custody of their kids. You're upending their lives and you're making it so much harder for them to be able to continue a law-abiding path afterward than not. And so the over-detention is actually a public safety problem, but that won't make the cover of the New York Post, and therefore, that's not what is driving what our policies are.
I'm going to ask one more question, then we'll go quickly to some your questions. So the last question I have is, what is one thing you would like for the audience to walk away with today? We talked a lot about a lot. So what is that one thing?
I think the one thing is that although I think a lot of these policies seem like they would make us safer, longer sentences, more detention, cheaper prisons where we crowd people in so we have more money to spend on more law enforcement. I think the intuition is that those things are necessary to keep us safer, and the court fell for those intuitive arguments. And I would like the one takeaway that people have is to realize that that's the tragedy of all this, because the court sold away our civil liberties and our rights for what it thought was a trade-off of making us safer. And as it turns out, those things do not make us safer. And in fact, there's so much empirical evidence, in part put out by the Brennan Center, among other organizations, that so many of these policies make us less safe. You incarcerate people for too long of a period of time. When they do reenter society, you've made it that much harder for them to do so. You put them in overcrowded prison conditions, and they are in a situation where they're developing really bad interpersonal skills and mental health issues that, again, is going to make it much harder for them afterwards. Pretrial detention, as I mentioned, is something that is actually worse for public safety. And so a lot of these things end up being counterintuitive, but if you look at the empirical evidence, it's very clear. And so this is like the worst bargain we've ever made, because we got rid of really valuable constitutional due process protections and we traded them away for what we thought was going to be public safety. And in fact, we got policies that made us less safe, and we didn't invest in the things that would have made us more so. I'm ending with a takeaway that is very depressing and down, but I do think it's important for people to know that.
Preet, did you have a takeaway?
Same question. Oh, so I agree with everything Rachel said, and I would give another sort of related set of examples. I'd like people to leave here and think about, why it is that we are not smarter about our policies and what our biases are with respect to those policies. So, for example, we shouldn't just care about the numerosity of people who are confined or how long they're confined, but what the conditions of confinement are. And every study, you talked about studies, but you don't even need a study to know that one of the most important ways and most effective ways you can cause someone who happens to be incarcerated to come back out into society and be productive and have a job and be able to support themselves and their families and everything else are various programs you can have behind bars, including vocational programs, educational programs. And the amount of opposition to the expenditure of a few dollars on those programs in prison turns people off. It turns off, people who are part of the officers' unions. It turns off some people who are voting on these measures. And you have to think to yourself, why is that? And I think in part it's this misperception about what's effective in rehabilitation versus what they feel is punitive. So the term of imprisonment is not enough to be punitive, and the denial of your freedom for a period of time and liberty is not enough to be punitive. But how dare you give to somebody an opportunity to learn to read better or write better or learn a trade or something else because they're a bad person, they did something wrong. When the way to think about it is, how are we going to have a more peaceful, more prosperous society and have these folks not have to go back in? And your neighborhood and community is going to be safer if you spend money on those things. The other example that's very common, and I think people have moved more in favor of this than they had before, you have a lot of people in prison and they need to work out aggression. One of the most simple and cost-effective ways to reduce violence in prisons is to have gym equipment. And I know a lot of them do, and you see what they're like sometimes on television, sometimes correctly, sometimes not. But again, when you start to put in gym equipment and weightlifting equipment in an incarceration facility, the officers folks get upset and say, look, well, they have a free gym membership, and they're here after having been convicted of a crime. That's the wrong way to think about these things. And there's example after example after example of that, where we're not smart about these things because we want to be punitive. Like, completely sort of different area, but parallel to this that I think about all the time. There are lots of people who think the way you're supposed to interrogate people shouldn't be soft. Every bit of evidence, both in terms of studies, history, and lived experience, my own personal experience in questioning people and knowing officers and agents who have questioned people, is that the most effective way to get admissions, confessions, if you will, or just other bits of data about what happened in connection with some conduct that they're being questioned about is to actually be nice and polite and have rapport and give them a sandwich and respect their dignity, and you get the truth. And enhanced interrogation techniques don't work. And so if that's the case, I often find myself wondering, as do a lot of people, I'm sure many of you do, well, why in the hell do we do the less effective thing? And it's like the gyms, and it's like the vocational opportunities. There's something about a certain mindset that says, you suspect this person of planting a bomb, why would you ask them nicely? It must be true. It must be true that pointing a gun at their head or threatening to chop off a toe or waterboarding, it must be true that that's better, and it's not.
All right. So going quickly to some audience questions. We've got a few in already. So this question for you is for you, Rachel. Why did Europe and other advanced democracies not follow the U.S. trajectory from the 1970s on, especially since they presumably don't face the same constitutional constraints?
Yeah, no, it's a good question. It's complicated, but I think there's a couple reasons that we have a different path. So one is we elect a lot of important people in the criminal justice space in America, and European countries do not do that. So we elect prosecutors, we elect sheriffs, we elect judges. They think that's bonkers. And when you have elections for those positions, all of the dynamics that Preet talks about are relevant, because if you're running for those offices, a couple more recent progressive campaigns aside, you usually win those elections by being tough. And in European countries, instead, it's a much more bureaucratic, elite, professional kind of environment for setting criminal justice policy. So it doesn't have that kind of direct populist impulse for severity. So, that is one really important difference between Europe and America. A second important difference is, they weren't experiencing in those countries the same spike in crime that we were in the United States at the end of the 1960s, and we're also a much more heterogeneous population here. And so as a result of that, I think we have a history in this country of racial discrimination and disparities that also feeds into our approach to criminal law and punishment. And that was certainly something that prompted that push to severity. Lots of racial undertones, overtones, sometimes very explicit tones, to adopting severity. And, that was not present in Europe at that time. Interestingly, though, as European countries today are getting larger percentages of people coming in, of immigrants and people of color, they are becoming more punitive. And so there is a turn in some of the policies in other places that is looking more like the United States. But again, because they don't directly elect, it's still going to be a little bit more muted than what we've seen. But it is interesting that they're starting to experience the same dynamic. For example, they're now starting to turn to pretrial detention on the basis of dangerousness, even though it violates, various European charters and things they're supposed to comply with. And a big driver of that is the rise in migration in Europe, threats about danger that are experiencing there. So, we have some parallel things that I think maybe there's more of a lag there, but ultimately I think it's our direct democracy participation that in America means that we don't have a lot of filters for that push for severity, unless our court steps in, whereas they have an elite professional bureaucracy that acts as that.
Next question also for Rachel. What would an originalist analysis say about immigration detention?
Oh, okay. So, well, that's not my field. I'm not an immigration expert, but I will tell you that certainly the notion of due process is at the core and the backbone of our Constitution. Like that I cannot stress enough. So the idea that everybody every person is entitled to due process before they are deprived of life and liberty is a cornerstone. Now, what that due process looks like, I leave to the immigration experts exactly what it is that you get. But you do get due process, and it is eerily similar, I will say, the kind of arguments we're hearing today from the administration to the kind of arguments that I saw in some of these cases about the need to, we couldn't possibly give all the process because it's too time consuming, it's too expensive. We have this urgent need and you need to allow us to kind of cut those constitutional corners, are very similar to the arguments in these cases. So I do think there are those parallels, which I hope, will not hold sway. One difference today from when the government made these arguments previously that I think is interesting is I think the government, I'm sure, Preet, every time you stepped inside of a courtroom, you kind of felt like it's good to be representing the United States. Like, it's good to be a government lawyer. You go in, judges kind of know you're there for the government. You represent the government. There's a presumption.
Not always today.
Well, today is really interesting because I think the current administration has, told so many falsehoods and has gone back on its word in proceedings, this is all on the record stuff, I'm not making any of this up, that it's losing that, I think, well-earned previously credibility where the government tried, to be a good faith actor and kind of do what it was supposed to do. And so it will be interesting to see if that makes a difference when the current administration claims we have to do this as a matter of public safety, and we just can't be expected to do that. I think it may be different than in the past when those arguments were made, because I think there's less of an assumption that there's a lot of truth behind that, and every other thing was tried before they got to this point. So I'll leave it there, and I'll refer to my immigration colleague experts for the specifics.
Can I just say one addendum to that? It's really important what you're saying about the perception of whether or not the government is telling the truth, and whether or not the judiciary in particular believes that. That Judge Wilkinson decision from the Fourth Circuit about Mr. Garcia, to me, the most important sentence and the most sort of compelling sentence in the entire opinion is after he says, the government claims that Mr. Garcia is a terrorist and a gang member. And he writes, perhaps not, which is exactly the way you're supposed to be. And he's just reciting the idea that due process is core to all of this, whether you're talking about people who go back to the Mayflower in this country or somebody who just came recently. But implicit in that is, I don't know if I believe you as much as I used to believe you.
That's a good point. This question is for both of you. What are the most ways to change, quote, punitive culture, end quote? And then the second part of that question is, how big in difference can progressive prosecutors or prosecutorial discretion make given the political constraints?
No.
Really? Okay.
I'll give you time to think.
Okay. So I'll start with the progressive prosecutor one. So when I said in my last book, I had these 3 ideas of like, what could you do? And there was a chapter on you could elect prosecutors that have a different platform and understanding of public safety, and in part understand some of the things that, Preet and I have talked about. They understand this empirical evidence, therefore they would understand that get tough is actually not making your community safer. There's actually better ways to do that don't always involve longer sentences or more detention. And, elect people that understand that. And I think that's at the core of this so-called progressive prosecutor movement. But, I think there's limits to how far that can go. So for starters, the kind of people that can win those elections have to be in communities where there is an electorate that is receptive to those kinds of arguments. And, that is not going to be true in big sections of the United States. It's still the case that in a lot of communities, that kind of get tough messaging, that's the right soundbite, that's the right way to win a campaign. They're just not going to break free. And, we've seen across the country, some of the prosecutors who ran on progressive platforms, like Larry Krasner in Philadelphia, was reelected, in spite of the fact he's had a very progressive platform. So it can be done, and it can be done repeatedly. But at the same time, we've seen prosecutors like in Los Angeles voted out in, a progressive city, but wasn't able to hang on. And, similarly in San Francisco, the prosecutor who was elected there got recalled. So I think that it's a movement that is important. I endorse it. I endorse it because I endorse public safety. And I think these are the kind of prosecutors who understand that, and they do a good job about realizing that, I could posture in front of you and claim just asking for longer sentences and high-profile cases is going to do it. But in fact, we need to do some other things that are actually more important. That, I think, is really valuable and a good thing. But I don't think it's going to make a dent in mass incarceration the way that it should, in part because I think these political dynamics are such that it's going to be very hard for these folks to continually either get elected in the first place or get reelected. They're often blamed for things that they're not responsible for. So for example, in San Francisco, one of the big reasons that Chesa Boudin, who was the prosecutor there, he's blamed for things like the unhoused population in San Francisco being so large. And you have to ask yourself, how much can a district attorney do to address a housing crisis? In cities across America, we just don't have enough affordable housing. We don't have enough, support for people, and therefore a progressive prosecutor could really only do so much. And so if you're going to blame them for those kinds of policies, they're not going to win their elections as a result of that. And so I think it's asking them to do more than they're really going to be able to do is also going to mean that they're going to lose elections. So I like the movement, but I'm not super optimistic that's the core. My big kind of what I would like to see us do that I think is the most productive thing that we could do is some institutional changes. So they're boring and they're wonky, and I won't, but I actually think it is because we have all these direct elections and everything in America is so like, well, the people want X. That is not ideal for setting policy. Like you can imagine I guess we did just kind of do that, but if we did that for things like environmental policy, you don't really want that. You don't really want people who don't understand science or what's best for climate or who can understand that, but who are just thinking about their immediate economic needs, right? It would be better if you had an agency or a space where someone could look at the best information and the best policies possible and balance all that and do that with a little political insulation. To me, that is the best thing we could do. So when there's momentum by the people for change, I kind of like it to be institutional change, where you create bodies that have a little space. And I could talk about wonkier ways that you can do that, you can do kind of cost-benefit analysis, and you can make them have to have data to support their judgments, and those kinds of things I actually think are better. And again, it is one reason why Europe has had a better outcome than we have on some of these things, is because that's embedded in the way they do things. And I like democracy as much as the next person, so I don't want to be misunderstood on that basis, but it is still democratic to say as a country what we would like to do is we'd like to elect people who put in institutions who make smarter decisions. And we can still change those policies if we don't like them, but it's good to have that institutional mechanism. So that's what I would support.
Yeah, I think there's a lot of wisdom in all of that. And on the issue of the last point you made of appointing versus electing, there are limits to that too. I know we're being recorded, and I may have a case in this jurisdiction, but I'll just sort of say generically, you can get appointed to be the U.S. Attorney in New Jersey and query whether you are qualified to be such a person, and that person was not elected. My own little personal democracy protest, to overshare with you, is when I go to the ballot box, and maybe this is not a smart thing to do, when I go to the ballot box, I vote whenever I can. I don't vote for judges. I think it's nuts that people campaign to be judges because of all the pressures that you face to have a certain kind of intemperate policy in one direction or the other. On progressive prosecutors, I don't fully understand that that's a monolithic group, that there's a party platform for people who describe themselves that way, or that there's a platform to be applied to them from the outside. What I believe in is, having been a prosecutor for a long time and having also spent some time working for a politician, is that common sense is a very valuable commodity. And you know what? The average person doesn't want, I think, the average good faith American doesn't want our jails to be filled to excess because it doesn't make sense. The average person wants us to have smart policy, but the average person also wants to feel safe. And the average person doesn't like crime to go up. And the average person doesn't care, and I hope I'm not hitting a discordant note, when crime goes up a little bit and reformers say, well, crime is at an all-time low still compared to 1991. Nobody cares that in 1991 the crime was lower. What they care about is in 2024, in 2025, it's higher than it was in 2024. Because normal people and good faith people want their children and they want their families to be safe. You can achieve both of those things in various ways in policy, but also in understanding and empathizing with people all across the spectrum. Simultaneously being able to say, we should spend some money on educating people and improving their lot when they're incarcerated so they can be productive members of society when they come out. And also at the same time acknowledge that a corrections officer's job is really, really, really hard and really dangerous. And you can get killed. And lots of other things in between the difficulty of the job and getting killed are part of the practice, which is not to condone lots and lots of bad practices that happen and the intransigence of corruption at various institutions, including Rikers Island, which I oversaw the investigation of some years ago. So to take seriously, I think the people who perform best and who can be most effective in enacting smart policies, notwithstanding the biases of their constituents, are people who can deftly, in the political environment, because it involves elections often, not always, New Jersey, the prosecutors are all appointed locally, is to simultaneously be credible and believable when you're talking about reform, and also care about public safety and feel like you mean it. And in certain circumstances, I've said this to, I won't name who the person is, but a so-called progressive prosecutor. At the same time that you're talking about, relieving the criminal justice system of certain kinds of, perpetrators, whether it's fair beating or something else, or other kinds of things that are disproportionately enforced against people of color versus otherwise, there are other things where maybe you can be stronger about and tougher on, like sex trafficking, if that's a problem in your community. So like all things, it's easier said than done, but it's a balance.
All right, we unfortunately are out of time. We do have some great questions, but we're not going to get to them. So I want to thank you, Rachel and Preet, for this conversation.